welcome to Hot News. We are live on Pan-African Television. We are also live on Facebook at Pan-African Television, live on YouTube also at Pan-African Television. Those of you watching us on Facebook, you can share the Facebook Live for other people to also watch tonight's edition of the program. You can send in your views, comments, and contributions on our WhatsApp to text line displayed on the screen. We'll make a time and read all those out for you. You can as well leave your suggestions, questions, comments, and whatnot on our social media pages on Facebook, Instagram, and on Twitter at Pan-African Television. My name is Justice Appiah. Tonight on Hot News, we are discussing the press conference held by the National Democratic Congress today. They have expressed disappointment in the judiciary. They have also accused the Chief Justice and his posture in the just ended 2020 election petition. They have also spoken on the Chief Justice's decision to write to the General Legal Counsel to, of course, call or summon the former Attorney General in person of Dr. Dominic Ayini. Well, that is basically what we are going to be looking at on the show. But briefly, we'll be watching excerpts of, what transpired at the headquarters of the National Democratic Congress today. And when we come back, I introduce my guest for tonight's discussion. Let's listen to our first video where the General Secretary of the party touched on issues pertaining or issues bordering on the just ended 2020 election petition and the posture of the Chief Justice. Let's go and listen. We'll be right back.
We must say we are also struck by how positions that the current Chief Justice took in the 2012 election petition are completely opposite to his positions in the 2020 election petition. And we may ask, what has changed? Let me read to you a few sentences from Justice of the Supreme Court, as he then was, Ani Yeboah, when he dissented in respect of a ruling concerning whether the Electoral Commission should be ordered to produce certain documents. He said, and I quote, "In a serious matter in which the mandate of the entire voters of this country is being questioned through the judicial process, one expected the second respondent, as the sole body responsible for the conduct of elections, to have exhibited utmost degree of candor to assist the court in arriving at the truth. Surprisingly, the second respondent, Electoral Commission, opted for filing no pink sheets, leaving this court unassisted and thereby placing reliance only on the pink sheets supplied to the agents of the petitioners at the various polling stations in issue. While the second respondent elected to deny assistance to a court of law in search of the truth in a monumental case of this nature is beyond my comprehension." He continued, "I think this must be deprecated in view of the constitutional autonomy granted to it to perform such vital functions under the Constitution for the advancement of our democratic governance," unquote. And that was Justice Ani Yeboah in 2013. Yet, in the recent election petition, the same Chief Justice, Ani Yeboah, dismissed every single application on behalf of the petitioner to have the chairperson of the Electoral Commission, the same Electoral Commission, assist the court to establish the same truth. In 2013, Dr. Farijan went into the witness box and was subjected to extensive cross-examination. That was not enough for Justice Ani Yeboah then. This time, Mrs. Jean Mensah, having sworn to a witness statement and sworn to affidavits to the effect that she would be available for cross-examination, chose not to testify. Even an attempt to reopen the case of the petitioner to enable her be subpoenaed was rejected by the same Chief Justice and his colleagues.
That was the General Secretary of the National Democratic Congress. But once again, he has chastised once again on the rejection of some of the interlocutories they filed during the election petition. Let's go and listen to that video, so we'll be right back.
Why was the conduct of Mrs. J. Mensah not deprecated this time around? How does the Chief Justice, Justice Emine Boa, expect Ghanaians to have confidence in his impartiality and fair-mindedness as a judge in the face of these contradictory decisions by him? Also, the way and manner the Supreme Court unanimously dismissed virtually all the interlocutory applications of the petitioner without regard for the law, in some instances, further dampened our hopes in that important arm of government. You may recall, for instance, that in their ruling on the application by the petitioner to reopen his case to call the EC chairperson as an adverse witness, the Supreme Court disregarded the clear provisions of the Evidence Act of Ghana, which is the law in Ghana, and opted for a wrong interpretation of the Black Law Dictionary of UK. Black Law Dictionary's definition of adverse witness. We all know that where the law does not explicitly provide for any subject, you may borrow from other jurisdictions, but clearly not where your law states clearly what should operate in Ghana. You abandon that one and you go looking for advice from dictionaries elsewhere. In that ruling, the court said that a person cannot be an adverse witness until he has already mounted the witness box, despite the clear provisions of the Evidence Act of Ghana, which provides that in a civil action, a party or a person whose relationship to a party makes the interests of that person substantially the same as a party may be called by an adverse party and examined as if on cross-examination at any time during the presentation of evidence by the party calling the witness.
Welcome back. That was the General Secretary of the Opposition National Democratic Congress once again expressing disappointment in the judiciary. But I have the statement of the National Democratic Congress here, and I would want to read a portion where they have also spoken about the dictatorship of the Chief Justice and why they think that the Chief Justice's decision to drag Dr. Dominic Ayine to the General Legal Council was in a bad faith, and that's marks of dictatorship and all of that. This is what they've said. When the petitioner applied for a review of his decision and the court was presented with an opportunity to correct this clear error of law, the court refused to do so without any plausible reason. How then can anybody fault Dr. Ayine for saying that his hopes about the independence of the judiciary was dampened by the way and manner the court failed to apply the law and judicial precedent in dealing with some interlocutory applications of the petitioner? Friends of the media, our position on this matter is simple. Dr. Ayine's view about the independence of the judiciary are views he is entitled to in line with his freedom of expression guaranteed under the 1992 Constitution. He was courteous to the court and kept his language temperate and decent. He stayed within the bounds of professionalism. He was neither scurrilous nor scandalous. For him to be accused by the Chief Justice of disparaging Ghana's judiciary over these tempered and justified comments is not only bizarre and unfortunate, but speaks volumes about the Chief Justice. Clearly, the opinion expressed by Dr. Ayine, which we in the NDC share without any equivocation, is not actionable and does not violate any rule or professional conduct rules for lawyers. As a matter of fact, neither Dominic Ayine nor we in the NDC can be compelled to increase our confidence in the independence of the judiciary, even when the court has not given us any basis or reason to do so. The Chief Justice ought to be reminded that justice emanates from the people and is administered on behalf of the people. Public confidence in the independence of the judiciary must therefore be earned and not forced on us. Ladies and gentlemen of the media, we are concerned at the semi-judicial dictatorship that is festering under the leadership of the current Chief Justice, an unwelcome development which threatens free speech and could potentially undermine our justice system. You recall that not so long ago, the Chief Justice instructed a lawyer, Mr. Thaddeus Sori, to issue a threatening letter to media houses in the country, ostensibly to restrict public criticism of the court on grounds that the Ghanaian people are uneducated and uninformed about legal issues. When there was public uproar, it was then claimed that the letter was not aimed at preventing criticisms of decisions of the Supreme Court in the media. Now, let me take the very final paragraph here, and then I introduce my guest. The judiciary, like Parliament or the executive, is not above criticism. Indeed, it is worth recalling that the recent Riakoto event in Kumasi, where an address was delivered on behalf of the Chief Justice, was an event to criticize a 60-year-old decision of the Supreme Court. The event was dominated by politicians of the New Patriotic Party stock, who used the occasion to express their critical views freely. Ladies and gentlemen, we wish to reiterate the fact that the invitation of Dr. Ayine to appear before the General Legal Council is yet another attempt by the Chief Justice to intimidate and suppress views that are at variance with his views. Even if the Chief Justice disagrees with Dr. Ayine's views or deems same as erroneous, the statement made were decorous expressions of opinion about a judgment delivered by the Supreme Court and do not warrant professional discipline. A repressive march as a constitutional democracy will suffer a grave setback if the disciplinary committee of the General Legal Council were to proceed to hold an inquiry into this matter of Dr. Ayine's statement at the CDD event. Our constitution and laws protect the integrity and independence of the judiciary and not the sensibilities of judges. Judicial vanity is a threat to justice and must not be countenanced in any democracy. We therefore joined well-meaning Ghanaians to demand that the Chief Justice withdraws his petition against Dr. Ayine forthwith. We further serve notice that as a political party, we are keenly following events and shall resist judicial tyranny with all our minds. And this is coming from the National Democratic Congress, the biggest opposition party in the country. I've been joined in the studio by Awal Mohammed, who is a member of the New Patriotic Party communications team. He's a brother. Awal, good evening.
My brother.
It's been a while. After the elections, I've not seen you.
That's true. There is a saying in Sweden. But I'm back.
I'm glad my brother is back, and I have him on this platform. Also in the studio is Peter Mensah, who is a member of the National Democratic Congress communications team. Peter, good evening.
Good evening, Justice.
Let me promise my viewers that God willing tomorrow we'll discuss same issue, but we'll bring the legal luminaries on the show for us to, dissect this issue properly and see if the Chief Justice is engaging in, judicial dictatorship, if he's becoming a tyranny, within the judicial setup and all of that. We'll do that. We'll do that. We'll bring you some good information. Peter, how are you?
By grace, Charlie, we are managing. The system is tough. Everybody is managing.
But you are looking good.
It's just grace that is keeping us, Justice.
Oh, really?
Nothing but grace. I'm telling you, it is just grace because The system is
You
in a way
want
that,
viewers to believe you that the system is tough when you are looking so very good.
as I said, it is grace that is sustaining us. Sometimes you don't mind the appearance.
Okay.
Honestly speaking, if you judge by the appearance, Charlie, you'll be making a mistake. Honestly, most people out there, they just comfort themselves by appearing good. Yes, just to console and comfort themselves. But within them, within the pocket is dry. Honestly speaking, my pocket is dry.
Very well.
Yes.
How is the member of parliament for?
Oh, that's I have
honorable.
exactly. I have actually, as we speak right now, he's in the constituency.
Okay.
That's Esutifi South. So special greetings to my boss, Honorable Alaji Collins.
He watches this program.
He's watching.
Yeah,
and especially Esutifi South people are really watching. So a special greetings to my people, and then in Kasemu Kenko people. They do mostly watch your show.
Thank you so much, Peter, for your submission.
Okay.
Now let me start with on the National Democratic Congress's, press conference today. In fact, they have indicated that they have lost hope in the judicial system in Ghana. They have also accused the Chief Justice of engaging in, dictatorship. Your take on that?
Thank you so much. Good evening to our cherished viewers. And thank you so much for the opportunity. Justice, in any democracy, you have three agents of states or organs of state, depending on how you will want to say
Very
it.
well.
We all read political science, so I'm sure. Yes,
Exactly.
So they are the judiciary, the legislature, and the executive.
Yeah.
And they all have separate roles they play.
Exactly.
So in the Twi language, when you say Appiah, it is the three that is called Appiah. If you check in this country today, the judiciary do a lot of execution of almost everything that you see, because the executive and the legislature also has the law passing mandate. But the judiciary, I can tell you that it is the last state agency or organ that is now standing, looking at how we have bastardized the legislature and the executive. Today, if the executive executes any policy, even though we abide by it, but because there are politicians sitting up front, a lot of people will have some reservations about the decisions of that political, executive power. You remember when the president talked about lockdown, when he called for a lockdown of Ghana for 3 weeks. You had the General Secretary of the NDC coming to say that he was trying to lock down just to rig the elections. This was in March. So you can see the extent that we go in trying to bastardize the executive, even though we will abide by decisions from the executive. Again, when you talk about legislature, how many times have you ever heard that Ghanaians are happy when they hear that there is bipartisan inquiry by parliament? You get people to even laugh it off, because since 1992, I don't remember any bipartisan inquiry by parliament that has resulted in any changes. But their law-making mandate is respected, however you disagree with them. So if you look at the three organs of state, the two are dominated by politicians, but the last one, there is no politician there. These are people who are supposed to be independent. One of the cardinal principles of a democratic state is when you have an unbiased judiciary. So if you get to a stage where you get people to take the judiciary to the cleanest, it is problematic. I'm making a general statement. It is very much problematic, because every investor who is coming to Ghana, the first thing he will look at your security. The second thing, he will look at your judiciary. If the judiciary is robust, he's aware that if I invest my money and something happens, I'll get justice. So when you bastardize the judiciary, it's the last state organ standing now that even you and I, when we disagree, will take solace in going to court. When they bring out their decision, even if you disagree, you still abide by it. Even the legislature, after passing the laws, if you want even the interpretation of the laws that has been passed by the legislature, you still have to go to court. And the court decision becomes binding. It becomes law on its own. So when you have people losing interest in the judiciary, the state is heading towards, towards some kind of doom. Because a lot of people will lose interest in going to court. So you even have instant justice and so on. So if you check what Mr. Dominic or Dr. Dominic Ayine had done, it is a repetition of what he had said that landed him into the Supreme Court. He was hauled for contempt of court. Dr. Dominic Ayine is not a mere legal person. He's just not a mere lawyer. This is a senior lawyer in good standing. This is a former Deputy Attorney General of this country. This is a law lecturer who trained a lot of lawyers in this country. There are certain truths that it does not befit someone to say it, even if it is true. There is an adage in Twi that asembi se ohene ano, ebi se ahenkwa, ebi se ochiame, right? The chief is not everything that the chief can say. It's not everything that the ochiame can also say, and it's not everything that someone, just an ordinary person can say. So when you have such a person of his caliber trying to bastardize, I remember when he said those words at the Supreme Court, in front of the Supreme Court. I am not a lawyer. I had never wished to be a lawyer. I don't know if maybe the future will hold something, but I still don't want to be a lawyer. But when I heard it from my readings and so on, I said, this man has scandalized the court, even before he was hauled.
But
if you check my Facebook
post, the judges are not beyond reproach. They have erred, people must criticize them.
That is true.
Why are they projecting themselves as though they cannot be criticized?
You can criticize the judgment. It is done anywhere in the world. But you do not denigrate what the judges had done.
In his statement, what denigrating did he say?
When he said that if you look at the 9-0 that has been given almost all the time, they have predetermined the outcome of the case. That was what he said. So he has indeed scandalized the court by trying to say that he is before the court, but the court has come with its own decision. This is not someone who is supposed, if it is Peter Mensah who had said this, I don't think you will even be hauled for before the
NDC in its statements has made an analogy.
So before I even get to the NDC statement, I will want to say that Dr. Dominic Ayine has also even contradicted himself, because after saying all these things in Supreme Court, he went to court and he said in his own words that he has heard, he erred in what he has done, and it was unbecoming, these are his words, of a senior lawyer of his stature to even scandalize the court. He admitted scandalizing the court. Then you go to a panel discussion somewhere and repeat the same thing and say that indeed you are right by saying this.
Those are his convictions.
So it was his conviction when he met the court. At the Supreme Court, he begged and said he erred. But when he went outside, he had convictions. But in the court, he did not have any conviction. But when he went outside and was talking to media, he had conviction.
After his apology in court, you realize that the case continued. What if the court, after his apology, has done something he deemed to have been what he described in his statement?
If he had said something different, a lot of people had criticized. I have had cause to watch Inus of Husseini on this platform on a morning show.
The Good Morning Africa.
Yes, giving an honest criticism of what he feels.
Okay.
You understand? You can criticize, but you do not denigrate the judges by saying that they came with their own verdict, when you know that indeed when you compare the 2020 elections petition with the 2013, it does not gel.
What sets them apart? What makes them different?
Because in 2013, you had Dr. Baumia with 9,000 pink sheets in court to prove that indeed that election was rigged. You had him proving with concrete evidence. In 2020, you had Appiah Ketia saying that he did not come with his results when he was asked, when he was pushed to the wall. He said he couldn't even come to court with his results.
He indicated
when you had
they were in court subject or based on the results provided by the electoral commission.
He said they were in court to only look at the work that the EC had done, not to challenge the outcome of the results. He said this in court. So how do you juxtapose when we said that that elections was rigged and we came with concrete evidence to prove that indeed that elections was rigged?
It doesn't take away the fact that Afarijan was dragged into the witness box, but James Mensah was prevented from entering the witness box.
So these are two different cases. When you come to court empty-handed, without anything to prove that indeed you gave me these pink sheets. That was what Dr. Bamia said. You gave me these pink sheets. And on these pink sheets, we have 1 + 1 is this, and it doesn't tally. Come and explain. The man must mount the box to do that. But not someone who comes to court and say that when we were even at the strong room, the woman asked us to go and consult with our boss. So we went to consult with our boss. We left our computers there. We did not leave any person there. We went and consulted, and before we came, she had already declared. And again, he said, I went out to her office. He was even thinking about, I took tea, I didn't take biscuit. And you feel that this is something that you had sent to court to even get a verdict. What Appiah Ketia had done today, it only confirms what the altercation between him and a lot of the party people, the discerning party people, people like Dr. Benjamin Kumbo and others who are saying that that man, Appiah Ketia, betrayed the party. They said, bring the results that you collated. He couldn't do this, and he is gathering to go for national chairman. So he is trying to get some support to carry some favor from his own people. I am saying that Appiah Ketia, his press conference,
but he has not come out
is
to say
unnecessary. This press conference is unnecessary.
How do
it
you
is uncalled for
that
because
Appiah Ketia, General Secretary of NDC,
yes,
is going for a chairmanship position? That's an allegation.
But this is something that is out already. But I'm saying that this his press conference is unnecessary, vexatious, and it is uncalled for because
I want to read
the man. Before you read, the man who is accused, who has been invited by the disciplinary committee. Don't forget that this is a disciplinary committee hearing. He can go there and prove his case and go unscathed, or he can go there and also for them to also make a recommendation.
Isn't it a case that the Chief Justice is becoming intolerant?
It is not that case. What I foresee is that you sit here and work with Pan-African TV.
Exactly.
And one of, maybe the general manager or any other person makes an accusations against you. Then a committee has been set up as a disciplinary committee. If you know you are right, you wouldn't feel any, you would just go and prove your case. I have seen the 11-page response to the disciplinary committee by Dr. Dominic Ayine. Let the process work. The process of the discipline committee worked in the case of my own friend, the MP for Medina. Sosu. He went to the discipline committee. They found him guilty. He went to court. The court quashed that decision. So it is not conclusive that someone has been dragged to discipline committee. So that person has been hanged. He has not been hanged. He has gone to only discipline committee.
Now, the statements, ladies and gentlemen of media, the way in which the Supreme Court, in the hearing of the 2020 election petition, continuously shielded the chairperson of the Electoral Commission, Mrs. Jane Adukwe-Mensah, from scrutiny and accountability has been the subject of critical comment by many people. Indeed, much of the criticism has been from people who are in no way associated with the National Democratic Congress. We must say we are also struck by how positions that the current Chief Justice took in 2012 election petition are completely opposite to his position in the 2020 election petition. Let me read you a few sentences from Justice of the Supreme Court as he then was, Idin Yebua, when he dissented in respect of a ruling concerning whether the Electoral Commission should be ordered to produce certain documents. He said, quote, in a serious matter in which the mandate of the entire voters of this country is being questioned through the judicial process, one expected the second respondent as the sole body responsible for the conduct of elections to have exhibited utmost degree of candor to assist the court in arriving at the truth. Surprisingly, the second respondent, Electoral Commission, opted for filing no pink sheets, leaving this court unassisted and thereby placing resilience only on the pink sheets supplied to the agents of the petitioners at the various polling stations in issue. While the second respondent elected to deny assistance to the court of law in search of the truth in a monumental case of this nature is beyond my comprehension. I think this must be deprecated in view of the constitutional autonomy granted to it to perform such vital functions under the Constitution for the advancement of our democratic governance. Now, let's look at this paragraph.
Okay.
So I'm coming. We are coming to.
I'm even surprised that you are even taking this time to read this.
Let me read.
I get where you are arriving.
I've read what he said in 2012, 2013.
Yes. So,
and let's read what he has said in 2020 and see if there's some factual statement made by the NDC. Yet, in the recent election petition, the same Justice, Idin Yebua, dismissed every single application on behalf of a petitioner to have the chairperson of the Electoral Commission assist the court to establish the truth. In 2013, Dr. Afarijan went into the witness box and was subjected to extensive cross-examination. That was not enough for Justice Idin Yebua then. This time, Mrs. Mensah, having sworn to a witness statement and sworn to affidavit to the effect that she would be available for cross-examination, chose not to testify. Even an attempt to reopen the case of the petitioner to enable her to enable her appear in the witness box was rejected by the Chief Justice and his colleagues. Why was the conduct of Mrs. Mensah not deprecated? That's the question. How does the Chief Justice, Justice Idin Yebua, expect Ghanaians to have confidence in his impartiality and fair-mindedness as a judge in the face of these contradictory decisions by him? They have contrast, compare his
statement in 2013, yes, and
then now in 2020,
yes,
and so they have asked a very pertinent question.
So this
you have answered to that question.
This is simple. This is simple. The Supreme Court, its decision is not binding because the Supreme Court today can sit and make a decision. When you go for an appeal, they can reverse that decision. So when you go back and bring that decision that they had done in the previous ruling on the same case and say that the person is not consistent, then you don't know what you're talking about.
Marks of double standard?
It doesn't in the judicial process. It doesn't. These are two separate
what
cases.
Was right yesterday,
I'm saying that
today is not right anymore.
These are two separate cases. The first case is that we said the elections was rigged.
Okay.
And we proved, you see, he who alleges must prove. We took over 9,000 pink sheets to court. Come and prove. So the person will have the onerous responsibility to be in the box. But in this case, the person who went to court said, I am not in court. The same as who is talking says that I am not in court to say that the election has been rigged.
That NDC
he said it is Supreme Court.
Called that the NDC tried reopening its case to subpoena the Electoral Commission.
So on what basis did they go to court in 2020?
That was
what were the evidence they presented to court in 2020? There was no evidence.
They have made a case to show.
You see, you don't go verbal and be talking. That is not what you do in court. In court, it is evidence supported by what the documents. These are elections that was conducted in over 33,000 police stations across the country. So over 33,000 police stations, you did not even go to the court with even pink sheets, because these are the primary documents that you go and prove your case. You didn't go with all this. Appiah Dunketia is doing all this because his people who are very discerning amongst them is saying that it is time for him to go because he had failed them. When he went to the Supreme Court as the star witness, when he failed them, they had to go and bring a more irritated what's the name? The man who went and took, he said he took tea without taking a biscuit and so on. When he came, he even destroyed the case.
You mean Rojo?
Exactly. Because initially they said Rojo will not come. They knew that Appiah Dunketia will be the star witness. They brought in Pesa White, who is clueless about elections. So they brought in Appiah Dunketia, prepared him to come and execute. He came and was shambolic. Then they brought in Rojo, and he even destroyed the case. So these are the reasons why Appiah Dunketia will go ahead to organize press conference when there is no conclusive
I would have to be going to
decision.
But let me ask.
I'm saying that there is no conclusive decision on Ayini.
Wait a minute.
I'm saying that there is no conclusive decision on Ayini for you to say that we support him.
I'm asking.
It is just a subpoena. It is just an invite.
Allow me to ask you a question, my
come
brother.
to the
NDC has made another statement here, and they said the judiciary, like Parliament or executive, is not above criticism. Indeed, it is worth recalling that the recent Ria Koto event in Kumasi, where an address was delivered on behalf of the Chief Justice, was an event to criticize a 60-year-old decision of the Supreme Court. The event was dominated by politicians of the New Patriotic Party, who used the occasion to express their critical views freely. Now the question is, if a decision by the Supreme Court 60 years ago could still be criticized, why then somebody cannot criticize the current?
Did you really watch the program by CDD?
What
the program by CDD was to do an analysis of the 2020 elections, and there were criticisms on it. When you read what Professor H. Prempe said, Professor H. Prempe criticized some of the decisions. But you see, this man Ayini only sought to denigrate the judges, only sought to scandalize the very court that he worshipped.
Okay. All right. I'll come back to you. I'll come back to you. You're still watching Hot News right here on Pan African Television with me, Justice Appiah. Keep your messages coming in on our WhatsApp to text line. We'll make a time and read all those up for you. Those of you watching us on Facebook, you can share the Facebook Live for other people to also get an opportunity to watch tonight's edition of the program. Now, let me come to you, Peter, on the statement. What at all did the Supreme Court do that you think that the entire NDC would have to lose hope in the court, in the judicial system, and in fact that will warrant some sort of criticism? So what at all did they do?
Okay. Thank you, Justice. Let me greet our viewers once again. And then Omanana of God, so Genesis Radio is watching you.
Okay.
And he says he liked the show very, very
well. Very well.
Watching the show.
Good evening to you,
so
my brother.
Special greetings to you, and then my brother too. You see, I understand how Awal is really struggling, and then you were trying to. Oh, yes, you have done about 90% of the job already. In fact, trying to ask critical questions, and then he was really wait. Of what this contains, you know. He's a political science student, and I am a political science student as well. You know that our democracy, there was a point in our democracy that we say our democracy has been consolidated, and the consolidation of our democracy has to do with the free and fair electoral system Ghana has built over the years. So we say that, or we tout ourselves that we are beacon of democracy in West Africa and even Africa. The point is that all that happened in 2020 election and the subsequent election petition has come to actually undermine the credentials we have built over time. I was really disappointed when I heard or got to know that the Chief Justice has petitioned the General Legal Council over a comment made by Dr. Ayeni.
What's wrong if he has done that?
The point is that what comment did Dr. Ayeni
What comment did he make when he apologized to the court, when he was summoned?
It is not about the comment he made when he was summoned. The petition here is about the comment he made during the CDD program.
How different was that?
I am coming. I am
what he said.
I'm coming there. I'll be there. Because what he said during the petition, when the petition was ongoing, he apologized and then everything went a case down.
Okay.
But in this case, the focus of the petition was about the comments during the CDD program. And so here, the point is that the question, the program was about. Let me lay down.
I'll allow you
okay.
to lay your foundation properly.
Yeah.
But you have made a comment.
Yes.
You have made a statement that is scandalous to the court. Okay.
Yes.
The court has summoned you before 8.
Yes.
And you have apologized. And in your statement, you talked about the fact that a senior lawyer of your stature shouldn't have made those comments. So you were asked to come and apologize. Use the same platform to use in scandalizing the courts to apologize. And you did.
Yeah.
After the petition, there was a program.
Yes.
And you criticized the same Supreme Court one. I'm saying that in his criticism at the CDD program, how is that statement he made different?
That is where I'm coming. Fantastic. That's where I'm coming. So here's the point. So as I said, I was disappointed in hearing that there's a petition. Secondly, I asked myself, is the judiciary beyond criticism? Are they beyond reproach?
I'm not sure they are saying that they are beyond
That's the point. No,
so
there's no way. There's no way Honorable Dr. Ayeni's comment during the CDD program was to bastardize the judiciary. This is what happened.
What happened?
There was a question posed during the program.
What was the question?
That how do they see the independence of, because the whole program was about the presidential election petition and its impact on Africa's democracy.
Okay.
So the question was that during the election petition, has that election petition come to confirm the independence of the judiciary? Lawyer Okon from the MPP side said to him, there is judicial independence as a result of this election petition. That was his view. And then Dr. Ayeni also came in and said that, as a matter of fact, his confidence in the judicial system, as far as their independence is concerned, has been dampened because of facts 1, 2, 3. And the facts are 1. Yes, the facts are 1. You see, this was election petition that we wanted the electoral commissioner, who is the returning officer, to answer critical questions in the box. So you realize that the whole election proceedings, the electoral commissioner was shielded not to come to the witness box.
Who shielded the electoral?
Yes, the whole proceedings and Supreme Court. All attempts made by the petitioner through applications to ensure that the witness, the electoral commissioner mount the witness box and answer pertinent questions was overthrown.
I hope you know it's not against the law for the electoral commissioner.
You see,
to have said that he was not going to mount the witness box.
In the statement we made it clear that he swore to an affidavit and he swore to witness statement that he was going to mount the witness box.
Okay.
And then, just as we made reference to what the Supreme Court Justice Appiah said in the 2013 election petition, by saying that it was important, looking at the sort of election petition that was going on, it was important that the electoral commissioner then should have come out with the original document which could have assisted the proceedings in court. In the same vein, this 2020 election petition too, we needed the electoral commissioner to provide some document which will assist the proceedings in the court. So in this case, the electoral commissioner was prevented, was shielded, not to know the witness.
You have accused the Supreme Court of shielding the electoral commission. How did they do that?
I said, legally, we were, we applied for a subpoena. We applied for review. We applied for a document to be provided by electoral commissioner. All those applications were turned down by the Supreme Court. It was then. So the point is that Chief Justice Appiah, who in 2013 election petition said that the electoral commissioner should have provided some pertinent document which would have assisted the court. Today, as then he was just a justice of the Supreme Court. God grace, today is the Chief Justice of the Supreme Court, and he was chairing the 2020 election petition. And this is a similar case whereby the electoral commissioner is being required to provide important documents which will assist the proceedings in court, and the whole Chief Justice sat down and disallowed such an application. And you read it right here.
Done in a unanimous.
So unanimous, that is where I have problem. Because if that is where we have problem. Because when you compare 2013 election petition, you had so many dissenting views. In this case, we have a Supreme Court judge who, in one way or the other, criticized a process where the electoral commissioner was not allowed to provide documents. So in this case, you are the chairperson now. So at least at that point, you should show that this is your principle and you believe in that principle and you stand by that principle. But the Chief Justice did not stand by his own principle. And that is unfortunate. As you were reading, what came into mind, comparing the 2013 petition and 2020 petition and the statement made by the Chief Justice and what he made today, it clearly shows an act of a double standard here. Because on one breath, you claim that the electoral commissioner should have provided or should have been allowed to provide some important document which will assist the court. But in 2020, similar case, you did not allow the electoral commissioner to provide the same document that the petitioners were seeking for, which could have assisted the whole proceeding. That is one. Number two, there were so many precedents that in the proceedings we were expecting that in the legal proceedings we judge or we rule based on precedent. Evidence Act clearly stated, and then we quoted the various Evidence Act which buttress our point that there are some standards that have been set already. So based on such standard, the Electoral Commission should have or the Supreme Court should have allowed some of our review, some of our interlocutory application to go through. But they turned down most of our interlocutory application, even though we set out the precedent, we set out the various Evidence Act precedent, but they did not comply to all those Evidence Act precedent that we set.
Do you think that by dismissing your interlocutory applications serves enough grounds for the NDC to say that they have lost interest?
You see, in an instance whereby, as I said, we set out the precedent. We quote the precedent that has been set. We quote the Evidence Act, whereby it clearly shows that this application should be allowed or should be accepted. And the Chief Justice and other justices come together unanimously and dismiss such an application. In one way or the other, you may share an opinion that yes, they have the right to do that, but I also have the right to say that that undermines the judicial system. So if I say that undermines the judicial system and you call that bastardizing, I don't know how you want us to criticize the judicial system. I have set down my fact. I have set the various precedent. I have set the Evidence Act. and then all the facts available shows that this application should be at least considered, and you disallow the application, and I'm saying that undermines judicial system, and you're calling it bastardization. I don't know how you want us to really criticize the judicial system in the country. And that is what Dr. Ayine was talking about. But because these are some of the facts that during the whole court proceedings, it is not only NDC alone. It is not only NDC that was calling for the electoral commissioner to mount the witness box. It was not only NDC alone. Even some people in MPP.
Briefly, I want my producers to get me the tablet pretty shortly. And there's no cameraman in the studio currently, and it's becoming quite difficult.
And then another example. You could recall that at some point, Chachuti Kata made a reference to a book written by one of the judges. And they made a reference to some of the provisions in the book. And the judge denied his own book in court. Meanwhile, that book has been... Oh, please. He denied that. He said he disagreed with his book. And everybody watched that. The judge said he disagreed with his own book. But that same book is being used to teach students in school. Student lawyers in school. That same book that the judge disagreed with the provision in the book that lawyer Chachuti Kata quoted. The same lawyer disagreed. And we are using the same book to teach students in school. So all these things undermine the judicial system. Also, you had your time. Allow me. Also, please.
You keep on repeating yourself.
There was an instance where the electoral commissioner presented a fake document to court. That's from 13. According to CI 127, whereby it was presented to Dr. Pastor White to verify. Upon verification, he realized that when you look at CI 127 and that sort of from 13 that has been presented to him, that was a totally different document altogether.
By the National Democratic Congress backing the former Deputy Attorney General, not worrying. I mean, this is a judicial system that we must all, really hold in high esteem. A judicial system that is supposed to be very independent. Your posture is not worrying.
It is not worrying. It, honestly speaking, Justice, if we do not do this, we will not help in re-deepening our democratic credentials. What the NDC is doing today, it is to help strengthen the democratic credentials that we have done over the years. Because, as we said, the judiciary is not beyond reproach. They are not beyond criticism. We have to criticize them objectively. And these are some of the issues we are raising. That a whole Supreme Court will sit aloof for electoral commissioner to present a fake document to a court. A whole Supreme Court, not just any high court or any court. Supreme Court of the land, and the electoral commissioner can present fake document to the Supreme Court, and the Supreme Court will not find any important means to hold the electoral commissioner responsible for providing fake document to court.
You think that
these are some of the things we are talking about?
You have the right to criticize the court.
Yes.
And you are describing a Chief Justice who also feels that your criticisms are scandalizing the court as a result.
Yeah.
Petitioning the General Legal Counsel to, summon the former Deputy Attorney General to appear before it over this matter. And you think that he has done something so wrong for him to have been described as a dictator and a tyranny.
Justice, all the point I have
raised here. You have the right to criticize the court. You think that he doesn't have the right to respond accordingly if he feels that it is denigrating his person and scandalizing.
Which of the points I raised, which are the basis on which Dr. Ayine said that his confidence in the fact that we have independent judicial system has been dampened. The various points that I made, which of the point is scandalous? These are some of the things we should be looking at. When we talk about scandalous, bastardizing, the point we are raising, which of them shows that we are scandalizing or bastardizing the judicial service? We are raising critical, factual points, things that happen during the court proceedings. And they are fact. And the evidence is there, clear. And we are trying to express our displeasure. Just as the Chief Justice, Justice Emilio Yeboah, in 2013 expressed his displeasure about the fact that the electoral commissioner then did not provide important documents which could have assisted the court proceedings. And today, we are also saying the way the Supreme Court did not allow Manu de Mensah to provide similar document to assist court proceedings, we are also expressing our displeasure. So when we express our displeasure and you are calling that scandalous, I don't know what sort of criticism you want us to make about the whole court proceedings. Okay. So yes, the Chief Justice has the right to, in one way or the other, call on people not to scandalize the judicial service. But we are raising objective criticism. These are facts. These are things that really happen, and we are expressing our displeasure about all that happened. So if you are expressing about things that really happened that did not go well with us, about we trying to strengthen our judicial service, and we call that scandalous, I don't know how you want us to criticize the whole judicial service. And then my last point, my last point, you see where you read about Thaddeus Sori's statement, it was so appalling for the Chief Justice in the first place. It's all boiled down on the culture of silence, because a Supreme Court ruling is coming, and before the ruling comes, you are trying to put out a statement which in one way or the other will deter people from commenting, will suppress people's comment, opinion. But we live in a democratic system whereby there is freedom of speech, freedom of expression. People have the right to criticize every action of state institutions. So when you issue such a statement, in one way or the other, you intend to suppress the views and opinions of the public. It's not even NDC alone. And that one too is an unfortunate act that we all need to talk about. So when we talk about this and you say we are trying to bastardize or scandalize the judicial service, I think that is an unfortunate statement to make.
I'm grateful.
Yeah.
You have just 5 minutes. Yes. I'll plead with my director to give me some free time to wrap up properly. You have 5 minutes.
Justice, I don't know if Peter listens to himself when he talks.
Okay.
Because you're saying that you sought to criticize what the judiciary had done, what the Supreme Court had done to consolidate our democracy. You didn't do that. Because after doing all these criticisms and even taking them to cleaners, you concluded by saying that you don't even have any faith in the democracy again, in the judiciary again. You have completely destroyed that very institution. Because the NDC is not just a mere political party. That is why I kept on reiterating the fact that Appiah Ketia is only doing this for every election. Because I listened to Haruna Idrisu. When Haruna Idrisu was saying that, reconsider your decision. But never in any of Haruna Idrisu's words, or Inu Safuseni, or almost all those who disagreed with what the Supreme Court had done or the Chief Justice had done, had said that they had lost they had lost.
This is the position of the National Democratic Congress as a party.
Yes.
So all these people are
that is why I'm saying that it is dangerous for our democracy when you sought to criticize and conclude by saying that you don't have any faith in the judiciary. So where do you go again? Where do you go? That is the last state institution standing. Today, even when there is an assault case, you only seek refuge in the court.
But we cannot.
So when you sit and say that,
we cannot sit here and pretend that the judiciary has not been politicized. Are you pretending to say that the independence of the judiciary is guaranteed?
You see, when you have the judiciary, for instance, you sit here, you work as a host. Someone will call and say that you did not give Peter enough time, or maybe you were hard on asking Peter questions. And then you work with GBBF for MPP for Anna. You see, the moment you start hearing all this, that you're NDC, you're MPP, it means you're almost on the middle doing your work. So it is when the NDC is not in power that they feel that the judiciary has been politicized. You remember when Nana Okumkra said that they will purge the judiciary themselves. He was the national chairman of the NDC. Dr. what's the name? Nana Ukunka. What's the name? Dr. Kobineje.
The late Dr. Kobineje.
Yes, when you were in opposition in 2008, you said you will purge the security yourself when you come into government because you feel that they have been politicized. When you came your entire 8 years in governance, you never sought to criticize them. But today you are in opposition, you feel that it has been politicized. Did the politicization start only 4 years ago? No. These allegations has been there. And you see, what
is the judiciary really independent?
There's no independent institution. They are supposed to be seen to be independent.
Okay.
That is very important. Again, when you said the Supreme Court did not allow the
interlocutory application
for the bringing in of the document, the original document, you're not being fair to the Supreme Court, because the Supreme Court said that what are you questioning in the document that you already have? The photocopy is as true as, because they had already filed it in their evidence. And these are photocopies. And they said you have the copy, so produce the copies if there are contradictions.
If Madam Jane Mensah sworn in affidavit that she was ready to appear in the witness box.
So if I have some litigation with you, if I have some litigation with you, we go for two separate lawyers. So you will want to dictate to my lawyer how he conduct his case. The EC went to court to win a case. When they went to court, you came in, did not prove anything, and they feel that putting her in court, in the dock, she is not going to respond to anything because you did not present anything. You went there empty-handed. So if you went there with some kind of evidence.
In the interlocutories, which questions did she provide answers for? If there were no questions,
when they filed their petition, she had to enter appearance, which is very, very necessary in all judicial process. Whether you will mount the dock or you don't mount the dock, you have to enter appearance in the conduct of the case. That is where your lawyers will choose to do what they want to do. The lawyers feel that in any judicial process, they have their strategy. Their strategy is that we will not allow her mount the
because to mount the witness.
It is even easy. It is even simple and easy that when you entered appearance, you were supposed to come and explain to the court all your answers. Then your opponent came in with all his answers. He said, okay, I don't need to even come because the questions that my lawyers had asked him had proven as right.
Okay.
So the court should make its own decision. And the court made decision. Because you see, Asile Dunketia consistently in the dock said that they were not in court to just challenge the results because they did not even bring contrary results. Up to now, the NDC is yet to furnish their own members the collated results of 2020 elections. They still don't have it. You have someone who has been a general secretary of that political party from 2004 up to today. He cannot even collate results. The same person is coming out to only do press conference just to try to get the sensibilities of the NDC supporter. For the NDC supporter to feel that somebody is being witch hunt. As I said earlier, when you are called to a disciplinary committee, the case is not conclusive. Let me finish. Let me just end. When you're called to a disciplinary committee, you are there to only prove that you are right or wrong. Exactly. And he has written an 11-page response to the disciplinary committee. So what is the basis of this NDC press conference? When the person in himself had already responded to it. So you only came in. That's why I said these are vexatious. These are things that is done.
I want to ask you a question before I come to Peter. And the question I'm asking is that did Mrs. Jane Mensah swear to a witness statement?
Yes.
And also swear to affidavit to the effect that she would be available for cross-examination? in the 2020 election?
She didn't say that. There is no way that you say I will be available for cross-examination.
I'm asking a question.
There's nowhere in the appearance that you will enter. She swore to an affidavit. You see, when someone
to a witness,
she did that.
She did that.
She did that because that is the procedure. That is the procedure in court. Yes, that is the procedure in court. When you go, listen.
No, wait a minute. In effect, is that, you know, is that to say that you are available for cross-examination?
Yes, when the need be.
When the need be.
Yes, because your lawyers will have to determine whether you sit in or not. Okay. Because your lawyers will have to.
Why was it
that was why the NDC said we are supposed to bring 5. The NDC swore an affidavit that they will bring 5 witnesses. Okay. They ended up bringing 3. Where are the rest of the 2? So it is really selective amnesia. Okay. When you came in and said you will bring 5 people to witness, you came in and brought only 3 people. She said, I will come and stand in the dock. She said, I will not stand.
Step down for me.
So if for us to go. Really you did not also even provided the number of people, and you expect her to also come back and sit and say that I'm doing this. The matter is now before the discipline committee. The discipline committee will come out with their decision.
Okay.
Even if the General Legal Counsel brings out a decision upheld, even if they think that he has indicted himself, he can still go to court. I'm saying that he can still go to court and still redeem himself as lawyer Susu did.
All right. Thank you so much. Peter, take us home.
You see, I can really understand it who we won by Awar right now. You see, we opted for interrogatories. The reason why the interrogatories were rejected was the affidavit sworn by the electoral commissioner and the statement to the witness statement. So they had already filed that they were going to be in the witness box.
That she was going to answer those questions.
Exactly. So there was no need for us to go for interrogatories. That is why the interrogatories were rejected.
Very well.
So they acted in bad faith. So when we are talking about this, are we bastardizing the judiciary? Please allow me.
Let's go.
Go to 30 months out. Even 30 months out, their case. Interrogatories, they granted interrogatories.
That case has fallen flat.
Even 30 months out, discoveries. No, can you allow me, please? You were just doing merry-go-round. Even 30 months out, their case, they allow discoveries. The judge allowed discoveries and allowed interrogatories. How much more the Appiah court, who did not allow interrogatories? These are some of the critics. Oh, can you allow me, please? Can you allow me? You have your time, please. These are some of the things we are raising. Also, justice. You see, we are making a critical statement here that all that Dr. Ayumi said were just objective criticism, whereby I think the judiciary should take in good faith, in one way or the other, to work on so that we can strengthen the faith and the confidence people have in the judicial service. Today, you know, Dr. Now, yes, he has made a statement regarding the same thing. So, can you allow me go to Modern Ghana? Oh, can you? Please allow me. Can you allow me, please? This is from Modern Ghana. He said Ghanaians likely to lose faith in judicial system. So when Naota, please, when he made this, can you allow me, please? When he made this statement, would you say he's bastardizing?
On what basis did he make?
Yes, because of the whole proceedings. One of the main reasons why he's making this statement is that, can you allow me? Why the Mensa was not allowed to man the witness box is in the statement. Another point, Alpha Barometer made a survey, and then according to the survey, 85% of Ghanaians perceive judicial officials as corrupt. If they come up with a survey like this, would you say they are bastardizing our judicial system? Please, can you allow me? You have your time. Please, you have your time. Why are you doing this? Why are you doing this? Please, allow me.
Let's wrap up on Afro.
What the NDC is trying to, the point the NDC is trying to make here is that there are so many people who are commenting. In 2013, after the election petition, lawyer Sam Okudoto, he mounted a podium to the Dankwa Institute and chastised and criticized the election petition. What did we do to lawyer Sam Okujeto? So why are we trying to chastise NDC lawyers when they are making comments, when they are making observations about election petition today? Is it not witch hunting? Is it not an attempt or a deliberate attempt to suppress or to tame particular lawyers, which in one way or the other they are affiliated to the NDC, not to talk on the election petition? That is what they are doing. So the NDC, as I said, we associate ourselves with what Dr. Ayene said today and tomorrow. And we believe that what Dr. Ayene said was in good faith. That's objective criticism, and the judicial service should take it in good faith so that we can strengthen our judicial system and then our democratic system.
I'm grateful for your time, Peter. Thank you so much, Awa, for coming. So give me 2 minutes to engage our viewers briefly. Justice, good evening. The 2021 election petition judgment was the lowest point ever of the Supreme Court. All well-meaning Ghanaians know that the SC judgment was problematic with their unanimous decisions. Philip in Wa sent in that one. This one says, when you decide to change the will of a people, you have done more harm to President Akufo-Addo than good. Jane Mensah and Eni Yeboah, you can never beat your chest or swear to God that you are happy over the current situation in Ghana, taking into consideration the political carnage and catastrophic economic Ghanaians are now facing. It's time for both of you to acknowledge the fact that some kindness can give one a lot of worries. Salam, Mamobi, good evening. Thank you so much for your message. This one says, good evening, my brother Justice. Justice, any serious country, the Chief Justice should be, oh sorry, unfortunately I can't read. J-Jom in Taifa sent in that. J-Jom, come again. Fahadi in Pig Farm says, the way Awa Mohammed and his MPP people can twist and tell lies sometimes, it amazes the devil himself. All right, thank you so much for your message. This one says, Awal is only making noise in the microphone. He's not making... This one says, good evening to you and your partners. Please, are you aware that majority of temporary employees of EC who supervise the 2020 election have not been paid our allowances? It is true that the EC have invested our allowances for interest before paying us our allowances. Please, you people should help us know who is keeping our allowance for payment. It's almost 7 months now since election took place. It is a crime. Is it a crime to work for a country? Patrick in Sunyani sent in that one. So I thank you so much, my director, for... Okay, you do so, then we'll go.
Good evening to you, my brother.
Once again, he's
Tika Winner.
Tika Winner.
And Hussein in Kumasi.
Okay, so Tika Winner in Tamale, good evening to you. Hussein in Kumasi,
yes,
good evening to you too. Thank you so much, Aziz, my cameraman in the studio, for doing a wonderful job. Also, to my director, Sawa. Sawa is my director, and she doubles as my producer for today. Thank you so much for also being the set chest, my sound man. I'm so grateful. Thank you so much, Awal. Thank you so much, Peter, for coming. This is what time I'll ask on the program. Make a time with us same time tomorrow on this same platform. But I'll meet you also on Good Morning Africa in the morning. Goodbye.